Good morning, everyone. My name is Zheng. I'm the president of the IP and Cyber Law Society here at Duke Law School. On behalf of IPCS, welcome to the 5th Annual Hot Topics in IP Law Symposium. This year, we actually have a record number of registrations in terms of attendees. We have about 180 registrations, nearly doubling the number from last year. And also this year is really the first time this symposium is also actually live webcast through Thomson West. So this is the first for the school. And I'd just like to make a few acknowledgments real quick. First and foremost, I'd just like to thank the entire board of the IP Society for their really tireless efforts over the past few months putting this symposium together. Actually, all their names are on the back of the program, and then they wear the name tags all marked in the rec text. So if you all run into them, please join me to share a few words of appreciation for their efforts. Next, I'd just like to really quickly thank our sponsors this year, and this symposium would not be possible without their generous financial support. And then all their names are listed right there on the banner. And this year, we actually have a record number of new sponsors, including Kilpatrick Stockton, Dorsey and Whitney, Sherman and Sterling, Alston and Bird, Wilson Sansini, North Carolina Biotech Center, Smith Anderson, as well as Morris Manning. And also, I'd just like to thank everyone for coming, especially the 40 also practitioners that are here sharing the day with us. I hope you will enjoy the program, help us spread the words, and then make our future symposia even more successful. And this symposium is, as Duke Law's only completely student-run symposium, and it's really a testament, truly a testament to the strengths of the Duke's growing IP program. And lastly, before I turn the podium over to Dean Bartlett, I'd just like to thank Dean Bartlett for her continued support of our organization. And without further ado, here's Dean Bartlett.
Thank you. I want to welcome you all to Duke Law School. I know some of you live here. Some of you are returnees, and I believe some of you have never been here before. I invite you, while you're here, to take a look around the building. We're really proud of our new addition, which is the area as you go out of this room and take a left. There's one floor down is a whole new clinic space, and then the other 2 floors are seminar rooms and faculty offices. We've got new classrooms, and we're really pleased with the way the building is taking shape. I want to return the favor and congratulate Zheng Bao on this terrific conference. There are many, many students who have worked hard to make this happen. I believe Zach Rentz also deserves some special applause, but I hope you'll take note of those people who are indicated as student leaders on their name tags and thank them if you're enjoying the conference, because they've really done a lot of work to put this together. I've just returned from a visit to one of Duke's peer schools where there is really a lot going on, but one of the things that really struck me as a difference, I'm not going to name this school, but it might be, possibly could have been any school, is the amount of student initiative at Duke Law School is really amazing. This is the 5th year of a conference which every year just gets better and bigger and more impressive, and more people are tuning into the webcast and wanting to get the materials, and really it certainly gets some faculty support, and I know they appreciate that support from folks like Jennifer Jenkins, Jamie Boyle, David Lang, Arti Rai, but I think all of them would concede that this is really a monumental student enterprise, and we're really proud of it here at Duke Law School to have this group, and as well as a number of other student groups who do so much to enrich the intellectual life of the school. Not only is this effort an indication of the enormous student enterprise at Duke Law School, but also a sign, of course, of the strength of intellectual property and related subjects. So it's really wonderful for the law school to have an event like this that that draws attention to those strengths and really brings the world into Duke Law School to see some very interesting conversations on some extremely important topics. I want to also thank the sponsors. I won't try to name them all, but this is pretty cool, this banner, I think, and the banner will be on the webcast. It's being streamed out all day long, so as well as something that people can pick up later. So I hope the sponsors, in addition to the visibility that they get with students and with other folks who are attending this conference, are pleased with this really cool banner. We'll fight over it afterwards. Obviously, I also need to acknowledge the contribution of the very distinguished panelists. We have one set of panelists here, as well as the folks who are going to be up here later on during the day. This conference wouldn't happen without a lot of different segments, and certainly we're really pleased that we were able to attract such a very high level of outside speakers, practitioners, academicians, and so on. I think the next thing I'm supposed to do, correct me if I'm wrong, is to introduce Arti Rai. Is that right? Okay. Okay, I have these marching orders, and I've got to really stick to it. Okay, so next I want to introduce one of our key IP faculty, Arti Rai, who is probably a household name to many in this room. I have not an elaborate introduction to give her, but she's really a very important figure in our IP strength at Duke Law School, and does a lot of work in the patent area, and is the right person to introduce this panel. Arti Rai.
So welcome to everyone. I have Zheng in my class, so I can testify to how hardworking he is, and I'm not at all surprised to see how well this session is turning out, and I'm sure the rest of the day will as well. So the title of this particular panelist set of panelist presentations, and later on a moderated discussion, is Are You Afraid of Patent Trolls? I think that was meant to be a deliberately provocative title. As many of you probably know who are steeped in patent law, questions of so-called patent trolls and more generally of patent reform are extremely high on the agenda of a number of different institutions within our government, whether it be the administrative structure within the PTO, Congress, or the Supreme Court, which has recently begun to show a very significant interest in patent law for the first time in, some would say, the most significant interest is shown in almost 40 years. So, and then, of course, there's also the 800-pound gorilla of patent law, the Federal Circuit, the Court of Appeals for the Federal Circuit, which has always been interested in patent law issues and patent policy issues, but is obviously continuing its interest in all of these debates. We have, as Dean Bartlett mentioned, an extremely distinguished panel to discuss issues of patent reform, conceived broadly, not just legislative reform, but also some very interesting administrative initiatives that are taking place. A set of very interesting cases that are being decided by the Federal Circuit, and some of which have been taken up by the Supreme Court, and so forth. So patent reform conceived broadly is going to be the subject of our panel today. Rather than going through detailed introductions of each speaker before their particular talk, what I will do is give a general introduction of the panel, and then a detailed introduction of our first speaker, and then a more detailed introduction of each speaker as they come up. So I hope that will work, so you can have a clear sense of each person as they right before they begin their talk. Our first speaker today is an old friend of Duke Law School who has been here on many occasions. She is the Pauline Newman Professor of Law at NYU, and after a rigorous day of teaching yesterday, she apparently taught all day, she was gracious enough to take a very late flight out so she could be here bright and early this morning. She holds bachelor's and master's degrees in chemistry, spent several years as a research chemist prior to going to Columbia Law School, where she served on the Law Review in various capacities. She clerked for the Second Circuit Court of Appeals and then for Chief Justice Warren Burger of the U.S. Supreme Court, has been at NYU Law School for quite a few years, and has in that time, become a very, very prominent member of both the intellectual property community, the community that studies the federal court system, and also a very prominent member of the international law community. She is served as a member of various distinguished National Academies committees, and is also the reporter for a new ALI project on principles governing jurisdiction, choice of law and judgments in transnational disputes. So without further ado, Rochelle Dreyfuss.
Okay, thank you, Arti, in particular for explaining my disheveled appearance. Thursdays are a nightmare for me at NYU, but I was very happy to be invited here, so thank you for the invitation. You're never in the way, John. Well, I should start by saying how I came to write this paper, since some of you know that I'm not an antitrust lawyer, and also how it relates to patent reform, the subject for today. As Arti said, I've had the pleasure, honor, misfortune, you can choose the word, to participate in some of the debates running up to the proposals currently before Congress on patent reform. And as I've listened, I've become increasingly worried that the core problems won't be fixed by tweaking the existing system, which is basically what's currently being proposed. Patent rights have become very broad. They can cover inventions that are far upstream and that represent a wide range of research opportunities. In other areas where people enjoy such strong exclusionary rights, there are mechanisms, such as administrative agencies, that oversee their utilization. Now, we, of course, have the Patent Office, but the PTO isn't like other agencies. It issues patents, but it doesn't make the law, and it doesn't have supervisory power over how the patents it issues are actually used. So if we want a system that deals with problems of exclusion, we'll have to change the authority of the PTO, substantially revise patent law, both of which are great ideas but not quite on the table, or look elsewhere for new controls of the system. Now, as it happens, I was asked by the European University Institute, which hosts a yearly conference of international antitrust enforcers, to talk to them about the patent law, competition law intersection, and that gave me a chance to ask, what if? Could antitrust law be deployed to check excesses in the patent system? Now, I expect that some of you will be skeptical about taking this tack, but if the specter of antitrust enforcement does no more than make you take patent reform seriously, I'll actually be quite satisfied. But I also do mean this paper to be taken on its own terms. I think re-examining the patent-antitrust interface could be part of the reform agenda, should be part of the reform agenda. Now, why is that? Let's see if I explain how to use that. Okay, well, we've just gone through a period in which competition rules respecting patents have relaxed dramatically. Per se approaches were replaced with rules of reason. Two important forces were in play in that shift. First, a new perspective on licensing strategies. Parties were deemed to be rational actors, striving to achieve efficiencies. As a result, an appreciation for the pro-competitive effect of licensing restrictions took place. Take tying as an example. It used to be condemned as leveraging rights in a field where the patent had power to a field where the patentee hadn't made any contribution. But it came to be seen as useful, as a way to meter utilization and protect quality. And for our purpose, key here is we thought we could rely on licensees to reject deals that were not in their interest or in the public interest. Second, the shift to rules of reasons flowed from the view that intellectual property rights, IPRs, are not in fact true monopolies. They're exclusive rights, but they're highly limited. Copyright protects only against copying. Patents are supposed to protect applications, not nature itself. In theory, patents can always be invented around. These substitutes are crucial to antitrust thinking because they're thought to constrain the right holder's ability to set high prices or limit output. Once their availability was recognized, the case for antitrust intervention looked much weaker. Lately, however, I think we're seeing something new in intellectual property, unique works that must be used by everyone in a particular field. Without the discipline of near substitutes, the issue of the relationship between IP law and competition law needs to be reconsidered. So the paper you have addresses three topics. What are these things I'm calling unique works? Why are we suddenly seeing them? the tools we already have to deal with abuse and why they aren't working, and then what I like to see from antitrust law. So first a word on what I'm calling unique works. A good place to see them is biotechnology. What has happened is that the traditional lines that once policed the differentiation between public domain ideas and patentable applications have blurred. That line was once drawn in part by the subject matter requirement of patent law. Since only things made by man were patentable, products of nature, fundamental principles remained in the public domain. The line was further protected by the utility requirement, which draws a distinction between inventions that have utility for consumers, protectable, and those that have utility for researchers, supposed to be in the public domain. Unfortunately, however, these requirements no longer work as well as they once did. Genes and proteins, for example, pass both tests. In a sense, they're man-made. They can be patented even though they, like other natural elements, have wide-ranging applications. And like nature, they can't be invented around, at least not for all purposes. If you want to explore the function of a particular gene or protein in the body, you need access to that gene or protein. These are, in short, unique products, and their patents can be misused to stifle a broad swathe of inventive opportunity. There's also a second-order problem, works that make themselves unique. In these cases, there are many ways to create a product initially. However, once one version comes into existence, circumstances dictate that it alone can be utilized. It can happen through standard-setting organizations. A group chooses a standard, the standard is embodied in a host of products, then a patent on part of the standard issues, and everyone must deal with the patentee. It can happen through government action. The government adopts a protocol, and everybody has to utilize what the government said to adopt. It can also happen through market forces. An example is Microsoft's operating system. Network effects tip the market to Windows. Now it's locked in. Everyone who wants to create complementary products needs to use Microsoft's interfaces. So that's what I mean by a unique work. Of course, one could say that even if the assumption that patents and copyrights are not monopolies is now wrong, we're still dealing with rational actors who will license to others the opportunities that they don't want to exploit themselves. Unfortunately, that's not always the case. Indeed, another change in the antitrust landscape is the gradual realization that rationality is bounded by informational and intellectual capacity. We see some of this in the Independent Inc. against Illinois Tool case, one of the cases currently before the Supreme Court. That's a tie-in case in which purchasers of printer heads were required to buy the patentee's ink. Interestingly, the briefs filed by the new crop of economists don't make that old argument that purchasers can look after themselves. Instead, they evince real concern about calculating the total cost of the package. Not so easy. In the context of upstream patents, the problems of bounded rationality are several. It can be difficult for the right holder to conceive of and evaluate all potential prospects, particularly those far removed from its own expertise. Potential users may not be able to get enough hands-on experience to find potential uses, or as Suzanne Scotchmer has shown, if they've spent resources exploring possibilities, they may find themselves in a difficult bargaining position when they try to get to exploit their own downstream developments. Even rational right holders may have incentives to not exploit efficiently. They may refuse to license patent rights to those in a position to develop superseding inventions. Or if a patent protects sequential invention along a quality ladder, the patentee may not want to cannibalize its own products, and so it will milk each market before progressing to the next one. In any case, evidence is mounting. There's a recent empirical study by Scott Stern and Fiona Murray showing that publications describing patentable inventions are cited less frequently when a patent actually issues, and less frequently than articles that don't describe inventions that get patented. There's also plenty of casual empiricism suggesting that rights over unique products are inefficiently mined. Patentees that hold out for inappropriately large royalties, impose onerous licensing terms, or fail to monitor the progress of their licensees. And then, of course, there's Microsoft, and before it, Bell Labs, companies that insist on the right to control all aspects of foundational technologies, and enough money, skill, inventiveness to meet Schumpeter's ideal of an efficient, effective monopoly innovator. And yet, what have we seen? When others have gained access to their technologies, surprising, amazing advances were made, inventions that the companies themselves never foresaw. So the notion of the rational actor efficiently exploring its rights simply doesn't hold. Products become unique because they're far upstream or deeply complex. The multiple possibilities that the intellectual property rights protect can't be explored effectively by a single innovator, no matter how well endowed. Now, one response, of course, is patent reform. Trademark law has a way to deal with unique works. A word or a symbol that's needed in the marketplace becomes generic and loses all protection. In copyright, if expression merges with facts or with ideas, it becomes uncopyrightable. But these doctrines have very limited application in patent law. Attempts to deal with the problem of unique or complex words through patent doctrines have been failing, and it's fairly easy to see why. You can try excluding particular subject matter, but doing that creates uncertainties for future technologies and the current innovators of them. You could narrow the scope of patents. Germany is now trying to do that with genes. But if business opportunities are too few for a particular group of patents, then you'll dilute or diminish incentives to innovate. People talk about an expanded research exemption, but it's hard to craft it in a way that maintains incentives to develop actual research tools. And in addition, of course, there's the TRIPS agreement, which freezes the ability of member states to cabin IPRs across the board or for patent law on a technology-by-technology basis. Basically, IP law is a problem because it acts ex ante and paints with too broad a brush. Well, if intellectual property law isn't the solution to the problem of unique works, what is? Could the answer or part of it lie in antitrust law? Should we think, for example, of holdouts by patentees as attempts to monopolize in violation of Section 2 of the Sherman Act, and perhaps even use the FTC and DOJ for enforcement? There are several advantages to an antitrust approach. It deals with issues ex post, when the impact of licensing decisions is evident. It can be a kind of surgical intervention, tailored to particular problems and taking account of specific circumstances. It has the analytical tools to help decide when a work has indeed become unique. And finally, at least so far, it's relatively free of the constraints of international law. Admittedly, even after recognizing the conceptual errors and relaxing antitrust scrutiny, there are various doctrinal hurdles that would need to be overcome. The option of refusing to license is, after all, the essence of the right to exclude. Courts worry about incentives and view the rewards available through intellectual property as best captured by allowing right holders to make their own exploitation decisions. In the latest Section 2 case, Verizon against Trinco, for example, Justice Scalia wrote a virtual ode to the glories of monopolization. I put a tiny little bit of it up there. Further, absent demonstration that a defendant withdrew from competition, or at least a showing that others offer downstream products, courts are unwilling to infer an intent to inflict harm. But most important, both courts and enforcers tend to focus exclusively on price and output, as though those are the only considerations that affect consumer welfare. The approach is somewhat different in Europe. In cases like IMS, McGill, and Microsoft, 3 important moves were made. First, the European Commission, backed by the ECJ, adopted a broader definition of consumer harm, an understanding that consumers have a strong interest in the development of new products through innovation. Second is an approach to incentives that looks at the industry and not merely at the right holder. If the net effect of compelling a license is a positive level of innovation of the whole industry, then intervening is considered welfare enhancing. Third, there's less need for a record of past dealings followed by a refusal to deal. The Europeans see that a decision to use an intellectual property right to block product development is in and of itself a competition problem. It's dormant competition, doing nothing with the right except for blocking entry by those who would otherwise mine it for the benefit of consumers. The Federal Trade Commission and the Department of Justice have actually occasionally taken this view in the context of mergers, but the approach actually works better for refusals to deal. They've been criticized because in the merger context, it's quite a speculative argument about what future benefits of greater licensing would be. But with refusals to deal, you can know what the frustrated licensee wants to create and what assets it needs to use. And if the right holder isn't utilizing that opportunity, you can also rest assured that its own incentives are not significantly diminished. In effect, recognizing a Section 2 claim would allow the superior knowledge of the potential licensee to correct mistakes caused by the imperfect rationality of the right holder. Antitrust enforcement could, in short, solve the information asymmetry problem that otherwise frustrates efficient innovation. Now, this is not to suggest that every refusal to deal would be a violation of antitrust law, but it does call for more scrutiny than U.S. law now provides. To prevent the erosion of incentives to innovate, a recalcitrant licensor should be considered to violate Section 2 when a plaintiff can sustain the burden of demonstrating that a work protected by an IPR is unique, that refusing to deal creates actual harm, or actual potential for harm, in the sense that the patented invention is needed for a project that would enhance consumer welfare, and also that the right holder lacks an incentive-based justification for refusing to license. So let me end with this. To me, the Patent Act reads a lot like my students' exams. A decent attempt at the beginning. So lots of information about how to get a patent. A few mistakes in there, but a decent attempt. And then a complete drop-off. The Act tells you almost nothing about what counts as infringement, what the patentee can legitimately do with the right, and what the public can do with patent holders wielding these alleged rights in bad ways. As we'll hear, patent reform is aiming at rectifying some of those omissions. But there may well be an important role for antitrust law as well, and there are other commentators, Josh Sarnoff, Christopher Leslie, Scott Hempel, who are also spilling ink on aspects of patent abuse. And of course, we'll soon know more about what the Supreme Court thinks when it spills its own independent ink. So thank you very much.
So Professor Dreyfuss, as usual, was learned and provocative. I'm sure there'll be lots of opportunity for follow-up and inquiry, further inquiry, in the moderated discussion. Our next speaker is Brian Kahin, who is also an extremely distinguished scholar of, well, it's hardly possible to describe all the things that he has studied and worked on during the course of the 30 or so years since he graduated from law school. I think perhaps one could put it best by saying what I first learned about him from a colleague of mine. He said, Brian Kahin is the person, you know, we hear these jokes about Al Gore having invented the internet. Brian Kahin is the person who actually invented the internet. So that's how I was introduced to him. Now he is a fellow, as I mentioned, at the Computer and Communications Industry Association, Washington, D.C. I take it the years in which he was responsible for inventing the internet were March 1997 to January 2000, when he served as a senior policy analyst at the White House's Office of Science and Technology Policy, where he was responsible for intellectual property, internet policy, and electronic commerce. He has a resume which is just astounding in its breadth and depth, and so I can only give you a few more highlights. He is currently organizing a project on advancing knowledge and the knowledge economy in conjunction with the OECD, the European Commission, and the National Science Foundation, and also planning a follow-on project called Enablement and Control, the Expanding Ecology of Knowledge and Cyber Infrastructure. Truth be told, I'm involved with both those projects, so I have a real prejudice, but I think that they're just really groundbreaking, represent really groundbreaking thinking in the area of innovation. Brian Kahin.
I'm going to speak wearing two hats here. One is my trade association hat. So this is very much from an IT industry perspective, but I also hope to give it some academic perspective. First of all, I want you to keep in mind that what's going on in patent reform is taking place against a backdrop of an enormous economic change. So you have these sort of macro phenomena, and you also have these changes within patent practice. And it's important to recognize that the patent system itself does not have a good way to digest these macro changes. In fact, patent law, like most legal traditions, tends to be inherently backward-looking. Now, what we have going on specifically here is an expansion of the patent system that Rochelle had mentioned, so that it's moved away from traditional subject matter into new areas. And the ones I'm going to concentrate on are software in particular, also address services a bit, the business methods area. But I want you to think of software not as sort of a sui generis problem, as it often is considered, but as an extension of the complex technologies problem. So the impetus for reform comes from several different directions, but it's rooted in a perception of a quality problem that seems to be particularly bad and salient in software and business methods. And this is coupled with the troll phenomenon, these little patent-specialized companies, which in a way are the result of outsourcing and the unbundling, the deverticalization of the firm, and so on, and seem to be taking unfair advantage of the patent system in some way. Then we have this series of important documents. We actually begin with the National Academy study, because it began as early as 1999 and just took a long time to come out. And that study forms the basis of the legislative reform package known as HR 2795. So it's, these NRC, National Research Council studies are done by committee, so they tend to be consensus-based. The FTC study was an internal staff report and is actually rather hard-hitting by comparison. And what's particularly significant about it from a policy perspective is this in-depth analysis of the perspectives of 4 different sectors on the patent system, some of which, pharmaceuticals in particular, think the patent system is working quite well, on down the line to software and internet, which electronic commerce, which doesn't think so highly of it. Finally there, a book published by 2 economists, Adam Jaffe and Josh Lerner, came out in November 2004, called Innovation and Its Discontents, and the subtitle is How Our Broken Patent System is Jeopardizing Innovation and What to Do with It, or something like that. And this is a very interesting study because it, unlike the FTC system, which focuses on the economic problem and the interaction with particular industries, the Jaffe-Lerner book is kind of an institutional critique. So it's kind of a political economics perspective on the patent system. And it's highly critical of certain developments in terms of regulatory capture or capture by institutions. So one is, at one level, this is the capture by the patent bar, which thrives in the more business it has. Regulatory capture, particularly attributable to fee funding of the PTO and this mission, which I gather is no longer touted, to help customers get patents, which represented in sort of an extreme high point of capture back in the late 90s. The specialized court, which I'll say more about, the Court of Appeals for the Federal Circuit, described as by Richard Posner as a booster of its specialty, a kind of intellectual capture. And what's not addressed in their book, but which I will talk about, is the industry capture, particularly by pharmaceuticals and biotech, the industries for which the patent system is most important, and their interest in shaping it to their own image and needs. And trade politics I won't say much about, but you should be aware that patents, part of the importance of patents and copyright is that this is perceived as sort of the residual competitive advantage of the US economy. So politically that carries a lot of weight. Here's in short the thesis of the Jaffe-Lerner book. We turned patents into bazookas and started handing them out to anybody who asked for one. So it's a combination of making them more powerful and more and easier to get. And so that's kind of the kernel of patent policy under the Federal Circuit. Here it is pulled apart a little bit more. And the emphasis on non-obviousness, easier to get. Automatic injunctive relief is the biggest single item of potency, and for any subject matter, as long as it's useful, concrete, and tangible in result. A definition that the Federal Circuit came up with, it looks a lot like the utility test. It's never been defined, and they've never found anything that didn't meet it. Injunctive relief. Okay, so this is a big issue. It's now taken up by the Supreme Court in eBay versus Merck Exchange. This is a quote from the Federal Circuit's decision: "Leverage is a natural consequence of the right to exclude." We'll see what kind of leverage in a moment. So the first cut at the House Reform Bill tried to fix what the IT sector felt was a problem, that this gave too much power to the patentee in complex products. However, the other industries beat this back. It's deleted in the substitute version that came out in September, and Supreme Court granted cert. And so this problem is this simple products versus complex products, and the huge opening this creates for trolls. So here's the problem. Okay, patents on a single function in a complex product can essentially hold hostage the thousands of other potentially patentable functions in the product. And they also can hold hostage the value created in other ways, whether this is copyright-protected code, design, integration, testing, things that are either impractical or impossible to protect with patents. The leverage in forcing settlements, and you can see this going on in the BlackBerry situation, essentially allows the patentee to free ride on the investments of the infringing producer, all these other aspects of creating a complex product. And the frequency of this problem is actually tied to the low standards of patentability promulgated by the Federal Circuit, which result in these things we call patent thickets, the general opacity of the system, and ultimately the failure of the public disclosure principle, because nobody reads these patents. So going back to the non-obviousness problem, we've got a legal fiction here that you can actually distinguish between inventive things and non-inventive things, and you can draw a line between them efficiently. Well, what's happened over the years, and you can think of this in terms of a skew. We can't measure inventiveness directly, but there have been studies that measure patent value, and it looks something like this. So if you have a low standard of inventiveness, you're going to get a lot of inventions. And we've moved from this creative flash of genius standard articulated by the Supreme Court to the current standard, which is a bit indeterminate in some ways, but it's a low standard. And that in turn has created a larger volume of patents. And we have these institutional pressures at the several levels of capture to create more patents. And what happens here is, since there's inherently this zone of ambiguity between what's patentable and unpatentable in terms of level of inventiveness, is that you end up, as you push along the tail of this curve, with a large number of questionable patents, where there's substantial transaction costs in determining which side of the line it falls on. So there was a lot of testimony in the FTC hearings about this in terms of the opacity of the system. I picked this one because Texas Instruments has benefited greatly from the patent system, and here it's basically saying, not only do we not know what's out there, but we don't know what's in our portfolio. And this is what companies tell standards organizations all the time. Disclose? Well, we don't know what we have. We can't disclose. I'm sure we don't know that. I don't know that anything in my company's portfolio is infringing, but I can't bring everybody from the company here and give you that assurance. So going back to this expansion of the patent system, which is the third leg of that problem, the fact that we're now dealing with software, you can consider software and the services. What's happened is we've moved from this paradigm where a single patent has a good relationship to a product in the market. You think of a patented drug as being the best example of it. And we've moved in two directions, one towards increasing breadth, the business method problem, and the other towards increasing granularity, the software problem. And in fact, software itself spans from one to the other. Software can be patented at many levels of abstraction. So with the business method problem, is you have one patent covering many different products or implementations. So that the breadth of the patent actually preempts different technological implementations. At the other end of the scale, you have one product with many, many, many possible patents. And it looks, you can think of it a little bit like this. And when you get into the competitive dynamics, with software you have millions of producers, widespread independent invention. You end up with complex products, and the products are not necessarily polished products for the end market, because you can now also have a lot of value added coming out of those products. And you see this particularly in open source software, where anybody is free to modify or expand it. And you end up with hundreds of millions of users, which means massive potential for liability. Okay? So compare that to pharmaceuticals, few producers, a rough equivalence between patent and product, and sure, you have millions of individual users, but there's little potential for liability. It's not practical for suing people for taking infringing pills. So you have these radically different paradigms in economic terms, including the fact that barriers to entry are so low. To write software is to produce it and almost to distribute it. Whereas drugs have high barriers to entry, costly experimentation, testing, and marketing. And that's why you get few drug companies. And there's some other characteristics of software that also play in, which we don't need to address. Going back to the liability problem, here's the vulnerability to what's sometimes called patent value extraction, very fashionable development among some businesses with lots of patents. And this is a function, the vulnerability, the downstream liability is a function of the complexity of the product, whether it has been adopted as an industry standard, which means that the whole industry is vulnerable, the embeddedness, how hard it is to yank the infringing technology out, network complementarity, how many others are tied in. You're tied into BlackBerry servers, you can't get out of that, you're vulnerable. Value added downstream, and so forth. Visibility of commercial use, you can tell people are using Linux or what kind of browser they're using on the web. It's very public. So low standards for complex technologies lead to these epiphenomena. Portfolio racing, large-scale cross-licensing, and the same low standards of patentability that lead to those things also lead to trolls. And then these variations, the intellectual ventures model, a combination of the troll and the cross-license for the investors. Open Invention Network, the open source answer to intellectual ventures. So these are the issues, which I'm sure we'll hear more about, that divide IT and pharma in the patent reform legislation. And I think they're all gone. They're all out of it. Presumption of validity was actually never in it, but that was an FTC recommendation to lower the presumption of validity. So here's the TRIPS problem that Rochelle mentioned, which seems to suggest we're stuck with a one-size-fits-all system. Why did this happen? This is because the pharmaceutical industry wanted it. They got it negotiated in so that no country in the world could preclude patents on pharmaceutical products. Okay? And very interesting here, you have two generally accepted principles of non-discrimination and the field of technology wedged in between them. Okay, this is essentially kind of a constitution, a world constitution on intellectual property. Nothing in the US patent law that says this. In fact, here's a bill that was just introduced with 30 co-sponsors that suggests Congress should implement patent reform that reduces barriers to innovation in specific industries with specialized patent needs. So how can we do that sort of thing under TRIPS? Well, we actually have a number of technology-specific provisions on the books. So one option is to just ignore TRIPS. Judicial interpretation is okay. This is the Lemley-Burke thesis, that the Federal Circuit is actually making technology-specific use of patent levers. It's just not in the code, so it's some lawyers may understand it, maybe the Federal Circuit understands it, but it's opaque. Flexible interpretation of TRIPS, well, when you look at that language closely, you can see a considerable wiggle worm as to tweaking the standards for different industries. You got to have patents, but you might be able to vary them some. Another possibility is looking at economic factors that aren't technology specific themselves, things like this: the complexity of the product, the maturity of the field, costs of innovation. There's nothing technology specific about these kind of standards, but to actually build these into the patent system would be an enormous undertaking, and we don't have the institutional apparatus to do that. In fact, here is current Chief Judge Paul Michel saying how limited the Federal Circuit's perspective is. And here, this goes back to the beginning. Regardless of the changes in business and technology and so forth, the Federal Circuit is basically still looking at its precedent, whatever the lawyers are citing to it, which is its precedent. They write more cases, and the cycle goes on and lacks the benefit of being tied to evolving reality. So we end up with this paradox of, well, you're not supposed to discriminate in the way the system works, but you end up with wildly discriminating results. So the question is, can we move from a patent system which is rigid and non-discriminatory in terms of process, a very legally formalistic system, to a patent system that does what we want it to do, which is to promote innovation, to give us good results? Because if we have a system that works the way it is now, in which it favors certain sectors over the others, that's inherently an industrial policy that promotes investment in biotech and pharmaceuticals at the expense of investment in IT. So there is actually a paper which wasn't quite ready for prime time, but if you send me email, I'll make sure you get it. And Arti didn't mention this conference, but there's so here's our a conference I'm working on with Becky Eisenberg on patents and diversity and innovation next September. Thank you.
So I think from these first two speakers, you can get a sense of, as many of you probably already know, why patent reform is such an emotional and controversial issue. Usually emotional and controversial are not used within 5 words of patents, but it really has become so. Thank you, Brian, for a very provocative talk as well, and I'm sure that our subsequent speakers, who I think it's fair to say represent perhaps more of the establishment than our first two speakers, will have a lot to say in response. John Whealan is the Deputy General Counsel for Intellectual Property Law at the PTO, and he's also the solicitor of the USPTO, which means he is the person who primarily the first among equals in terms of arguing before the Federal Circuit, and also is extremely involved in writing the brief writing that's done by the Justice Department in terms of the briefs that are filed at the Supreme Court. He's personally argued 20 cases before the Federal Circuit and has written close to 150 briefs. In addition to everything else, he is an adjunct professor at a number of different law schools, including Franklin Pierce, George Mason, and Chicago Kent. And finally, last but certainly not least, he served as a law clerk to Judge Rader of the Federal Circuit. And he received his law degree from Harvard Law School at a time that was very closely overlapping with mine, when nobody taught patent law at Harvard Law School. So for those of us who had wanted to take patent law, we had to go down the road to get it. And we've commiserated about that fact. Things have changed greatly, and one of the radical changes in law schools in the last 15 years, some of you may not know since you're so young, you don't remember, you weren't in law school at the time. 15 years ago, there was no such thing as patent law in law school, in elite law schools, and now all that has changed. John.
Thank you, Arti. I literally used to bike down the Charles to go to Boston University to sit in on a patent class, and I shouldn't tell everybody, but I never paid for the class because they wanted like couple $1,000s to audit the class, and Harvard wouldn't give me any credit. So I was like, well, I'm just going to kind of sit there. And I learned a little bit. And Harvard now has 2 classes, which is good. And they finally figured it out. I mean, we figured it out a long time ago. But I'd like to thank Arti and the dean for inviting me down. I think Arti and I were speaking at another law school with a slightly lighter blue color at NC, and we were on a very interesting panel, and she asked if I'd be interested in coming here, and of course I would. And I'd like to echo the points about the students that are running this symposium, Zheng and his team of people. I've never been to one of these symposiums that was totally student-run, and I do about a couple of these a year, and it is extremely impressive that a group of students can do all this work so well. So I'd like to thank them for all the coordination. Arti said what'd you call me? The
More representative of
the establishment. That kind of means I'm old, I think, but.
You call somebody in a ponytail.
Oh, yeah, that's right. The ponytail's the establishment, but that's, I'll have to tell my wife that and see if she agrees. I actually don't consider myself a patent attorney. I've never written a patent application. I just like to litigate cases, and I went to patent office to argue cases at the Federal Circuit. And after doing that for a while, you realize, well, that's interesting, but it's hard to make policy that way because you have to get a case up, win it, get them to write it your way. And what we've realized is we're an agency and we write rules, and we can actually change policy a lot quicker by making some new rules that might change the patent system. And that's what I'm going to talk about. Brian did a nice job in referring to some of the patent legislation up on the Hill that is stalled, and we don't have that problem. We write rules and they issue, and maybe they get overturned, but we can actually try to move forward, and I think it would be irresponsible not to do that. How many people here have ever seen a patent? Okay. How many people here have ever filed a patent application or want to someday file a patent application? Okay, that's a decent number. That's more than I expected, and that's more than me. We put out some rules in early January, and I was out in LA talking about these along with the Supreme Court work, and I couldn't do both in this short period, so I'm going to focus on these 2 rules. And the guy said to me a bit snobbishly, he said, well, we're a bunch of litigators. I don't think we're interested in the rules. And I said, well, do you know what the rules are going to do? And he said, no. And I said, we are going to change the way current continuation practice works and limit claims. And he said, really? And I said, yeah. And this is going to affect both prosecution and litigation. We have gone out with these 2 packages, and my clicker's working. And our goal is to, about 95% of the people practice the right way. And our goal in doing these rules, starting them about a year ago, was about 10%, 5 to 10% of the people that what I would call don't do the best practices. And our goal here is to try to put a little more leverage, I better not use that word, but to try to put a little more requirements in if you want to be one of these, what I would call an outlier. And I would define the outliers. Most people file patent application, 1 continuation at most, file 50 or fewer claims, and file 25 references. And that's kind of your standard 90, 95%. But some people don't do that. And to not get into too much buzz terminology, if you go to the patent office and they say, well, nice try, you don't get a patent, you get to go again, and again, and again, and again. Whereas in court, if you lose at the district court level, what do you have to do? Appeal. So this going again and again and again is called continuation practice, and people can do it fairly easily right now. They just pay a fee and they keep going. And there are problems, I think, with letting people do that. Patents will pop up in 5 years on the iPod and nobody knows it. And there's got to be, I think, some closure towards having a more focused examination and a more efficient examination. This chart is actually pretty good. If you look, I guess the black doesn't work well, but I think you can see it. If you look at the top green line there, which is hard to read a little bit, the Patent Office last fiscal year, I think these are the numbers, had about 300,000 patent applications. And only 200,000 were new, in that they had never been filed or something like them filed before. And 1/3 had been refiled, a continuation, or there's other words for it, but let's just stick with that. So we started looking around saying, well, we can't get to the new stuff because we're working on the old stuff. And these numbers somewhat are different. Brian wouldn't be surprised based on technology unit, but I'm going to look at the overall numbers. And we said, well, maybe we should take a look at this. Not only are the numbers going up, but the percentage is going up. And you can see it's kind of going up on a 45-degree angle. And if we just don't do anything, before long, over 1/3, if not half, or 40% will be these continuation applications. And so we thought we ought to try to do something. This shows some of our pendencies. I'm not going to go through all the slides because of the time restrictions, but what we decided to do was to put some limits on when somebody could file this continuation. And what we've come up with and proposed, and this is out for comment until the middle of this year, and it may get extended. We're not looking to jam this down everybody's throats. We really want some serious comments, and these are pretty serious rules. So, but you could file one extra application. You could file one continuation. So we didn't cut everybody off at the knees and say, okay, we're going to get rid of 100,000 of these. But if you want to file a second or a third one, which last year was about 30,000, of the 100,000 continuations, about 30,000 of those were second or more, then you're going to have to explain why you need to do this and why you didn't do it sooner. Now, what satisfies that explanation? I've been on the road doing this a couple weeks now, and I actually have people working on coming up with some examples that we may try to put out. But anecdotally, in my head, what would satisfy it? The stuff's growing in the Petri dish, and it takes longer to grow, or the clinical trials take longer to do than the continuation period allowed, and I got to give you these new test results. That seems like a fair reason to let you file another continuation. The examiner cited a reference against me. He never did it before. I should get to respond. That seems like a fair reason to keep prosecuting the case. But how about, well, I don't know what my competitor's going to do, so I want to keep this in the system for 10 years so I can draft claims that cover their invention. That's not a good reason. It's a good business reason to do it, but we're not going to let you do that. Or I'm not sure if I really want to invest in this product, blah, 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 blah. Tough. So, and we don't want to allow, there's no reason to do this if everybody can just game the system. So, in your comments, if you want to suggest how people are going to plan to game the system, please tell us. We've tried to think of some of the ways. Several of the people in my office that have been working on this have been prosecuting patent applications from the outside. I just hired somebody from Lilly who did it. So I'm trying to figure out the ways people are going to try to get around these. But to be fair, I don't think we can do this without doing a better job. Now, I had some conversations earlier, and I don't want to blast the employee workforce of the Patent Office, but we basically hire 22-year-old people without law degrees to examine patent applications. And that's a little scary. And we are going to hire 1,000 next year, and 1,000 the year after, and 1,000 the year after that. And if you're concerned about quality or consistency, that's not the best way to do things. So I think these rules have actually started to generate some debate internally of ways that we have to improve our system. And one way we're going to do it is we're actually going to give you 4 bites of the apple. When you file a patent application, they reject, you respond, they reject again. you get 2 bites. You'll file a continuation, you get 2 more. There's also been some discussion last week. I was out at the ABA, and it was, well, maybe before you reject at the end, you should take a look at the case. And I thought that had some soundness to it. That if you're only going to get 4, they better be a good 4 bites from your side and our side. And if you split out your patent, if it's forced to be split out, it doesn't count. So we're not trying to clip you too much, but we're just saying, look, you get 4 bites. Those people that you don't have to show a raise of hands, but some people actually file patent applications. They translate a document from Japanese into English, don't even rewrite it, and file it at the patent office. I'll worry about it later. Well, you're only going to get 3 more tries. So I think people are going to think twice about doing this. The good news is for you patent prosecutors out there, your rates should go up. Not your rates, but your hours, because this is going to take probably more work to do. And everybody says, well, what we're going to do is we're just going to file a lot of applications. Okay, we'll take the money. But if you file a whole bunch of applications on the same day with basically the same inventors, with basically the same spec, guess what? That's 1 application. I don't care whether you gave us 4 filing fees. We're going to treat it as 1. It's going to be surrounded. So that's one way we expect people to try to game it, and we're going to try to stop. There's going to be a standing double patenting rejection, and we're only going to look at, as I'll show you in a minute, 10 of the claims. Effective dates are important. When does this go into effect? How is it going to apply? I haven't exactly worked out all the details, but let me promise you there will be no GATT bubble. Like on the day before this goes into effect, we don't want 100,000 applications. That will never have this rule apply. That will not happen. I'm still dealing with applications from the GATT bubble 10 years ago. Guaranteed that will not happen. But we also don't want to make it so retroactive that it's unfair. And we're not cutting you off at the knees. Instead of filing that continuation, what can you do? You can appeal. And the appeal, when you appeal, you get a pre-appeal conference, a post-appeal conference, and actually the time to decide an appeal has come down to only 6 months. But I don't think a lot of people file continuations because they don't want to appeal. They're just using it for completely different reasons. And we have people that look at these appeals, and if they're wrong, they kick them back. The second topic is easier. District courts use representative claims. Appellate courts use representative claims. The board uses representative claims. We're going to use representative claims. You file 50, we're going to look at 10. Let's face it, that's all somebody can do in a limited period of time. But I'm going to move through the numbers. But we won't issue a claim that we don't examine. We'll look at the independents, a couple dependents. And if you want all your claims examined up front, you can have it done. But it's going to cost you. You're going to have to do some work, which in the current law of inequitable conduct, nobody's going to want to do. Marcouche type, I'm not going to talk about that. It's too detailed. Again, effective dates. If you have claims in the system, you're going to get to amend them and change them for free. But if you have a pending application that hasn't been acted upon, this is going to apply to it. This is when the comments are due. The last thing I was going to mention briefly is we haven't done this yet, but this is going to happen in about 6 months, 3 to 6 months. If you give us a certain number of references, guess what people do? They dump in, the gentleman here, if I gave you 100 references and you're a patent examiner and you have 20 hours, are you going to read them all? No. So we're not. You get past 25, you're going to have to start talking about them. You get a big reference, you're going to have to start talking about it. And at a certain, you know what else everybody does? We're not going to give them the references until they're done. After the patent is allowed, then we'll give them the references. Are you crazy? Do you think any examiner is going to reopen up the file and relook at it all? Of course not. So we're going to say at some point, probably at the first office action, if you give us anything, you're going to have to start talking about it. Please give us good comments. If you think the system is working fine, you weren't listening to the last 2 speakers. But I've actually been taking notes along the way. I have people working on stuff right now of ways of cleaning up some of the maybe the unclear issues. they're not going to be a perfect set of rules, so we would appreciate any proposals you have. And here's my contact information. So thanks.
John's presentation pointed out one thing that's very important, which is that the PTO does have, it may not be quite like other administrative agencies, but it does have a fair amount of power with respect to procedure in particular. And procedure, as we all know, in our post-legal realist era, can often affect substance. So I'm delighted that the PTO is choosing to exercise its power in this way. Just my personal prejudice. I'm a big fan of having the PTO take more authority. Okay, so next on the list, I believe, is, yes, Ed Ergenzinger, who is somewhat a member of our local community, although not in Durham per se, but in North Carolina. He is with the firm of Alston and Bird, and I'm sure he's been listening to some of our more radical speakers, shall we say, cringing a little bit, because his intellectual property practice focuses in some of the areas where the patent system may be working better than it is in other areas, in particular in the area of biotechnology and pharmaceuticals. He works both on patent prosecution issues in particular, and as well as freedom to operate issues, and does client counseling in the area of biopharmaceuticals, medical diagnostics, medical therapies, and pharmaceutical formulations. He has a background in, and technical background in the areas of the life sciences. His PhD in neurosciences from the Wake Forest University School of Medicine, where he was a National Institute of Mental Health pre-doctoral fellow. He earned his JD from Wake Forest University School of Law, where he was co-founder and editor-in-chief of the Wake Forest Intellectual Property Journal. And he has been working on questions related to the Patent Reform Act of 2005, and is, I think, very well placed to speak on some of the issues that might be particularly relevant in that patent reform proposal to the biotechnology and pharmaceutical industries. So we're really delighted to have him here. On relatively short notice, he agreed to fill in for Murray Sproul, and so we're particularly delighted that he was so gracious as to do that. Thank you, Ed.
Thank you, Arti. And for those of you who know Murray, know he hasn't let himself go and put on a lot of weight. He apologizes for not being here today. I'm happy to fill in. In Mark Twain's Connecticut Yankee in King Arthur's Court, the Connecticut Yankee, Hank Morgan, sets out to modernize the kingdom after he achieves the status of perpetual minister and executive. In one passage, he remarks, "The very first official thing I did in my administration, and it was on the very first day of it too, was to start a patent office, for I knew that a country without a patent office and good patent laws was just a crab and couldn't travel any way but sideways or backways." We're talking here today about efforts to reform the patent system, efforts that have been prompted on a variety of fronts, relating to issues such as patent quality, perceived abusive patent practices, harmonization efforts to harmonize our laws with those of the rest of the world. And although different industries have different views about how these changes should take place, hopefully our common goal is to produce a stronger system that fosters our collective forward movement. Although a complicating factor, as we've heard already some today, is that the patent system impacts different industries very differently. Within the biotechnology and pharmaceutical industries, as you heard earlier today, in general, you have a relatively small number of patents that will cover a given drug or product, and concerns with respect to reform here tend to focus on obtaining strong protection for individual patents and ability to assert rights against infringers. By contrast, in the software and computer industries, an individual product is likely to implicate dozens or hundreds of patented components, and concerns tend to focus on relief from a barrage of threats from so-called patent trolls. Again, we've heard some of that this morning already. For the purposes of my talk, I'm going to be discussing the impact of selected provisions that have appeared in various versions of the bill from the perspective of the biotechnology and pharmaceutical industries. I'll probably be getting a little bit more specific than some of the other talks about some of the provisions of the various bills, but my intention here is to try to give you a sense of where the differences lie and how the biotechnology and pharmaceutical industries sort of see some of these issues as they've appeared in various versions. For biotechnology companies, patent protection is critically important. The majority of biotechnology companies have currently no products on the market. What they do have, at least the ones that are successfully funded, are patented inventions that can take years and hundreds of millions of dollars to develop into a commercially viable product or technology. Investors recognize patents as important benchmarks of progress in developing product lines and revenues, and it's a strong patent portfolio that serves to attract investment capital that supports these companies during the long road to market. Now, during the presentation, I'm going to be referring to different hearings and versions of the bill. I thought I'd just quickly touch on a timeline here so you can get a little bit oriented. The House IP Subcommittee of the House Judiciary Committee released a committee print of a draft patent reform bill incorporating recommendations of various industry groups back in April. Subsequently, hearings were held. H.R. 2795 was formally introduced in the House based on a revised version of that committee print back in June. In July, Chairman Smith offered a draft amendment in the nature of a substitute, and in September, the Coalition for Patent Reform, which is an industry group comprised of companies that include 3M, Eli Lilly, Abbott, produced a redlined version of Chairman Smith's draft, followed by a hearing to address issues relating to provisions in the various drafts. Now, what I'd like to touch on are selected provisions, as I said, to try to give you a sense for where the views of the biotechnology and pharmaceutical communities differ from other industries, such as the software and computer industries, some of those we've already heard about, as well as where there's consensus within the biotechnology community and where there's some debate. And this is going to be based on some published data from the Biotechnology Industry Organization, based on informal polling and discussions with industry representatives that work on their various committees and working groups. And so in this regard, I thought I'd break down some of the selected provisions into three groups, with those for which there's a consensus of support within the biotech community, designated as the good, and those where there's a consensus of opposition as the bad, and then where there's a lack of consensus as the ugly. You were wondering where that was going to tie back in. Well, there you go. So let's start with the bad. Injunctive relief, in large part a response to perceived abuses of the patent system, the patent troll phenomenon we've already heard about this morning. And this highlights a difference, as referred to earlier, between the pharma and biotech industries and computer and software industries. Computer and software industries face constant challenges from patent owners that use a threat of permanent injunction on one component of a product to shut down the whole product line, and to, in some cases, extract disproportionately high royalties. Now, the committee print initially raised standards to obtain an injunction by eliminating a presumption of irreparable harm and requiring consideration of the extent to which the patentee makes use of the claimed technology.
HR 2795 was more modest, instead including language to increase the possibility that permanent injunctions would be stayed pending appeal. In order to stay an injunction on appeal, alleged infringers would have to show that the stay would not cause irreparable harm to the patentee and the balance of hardships would not favor the patentee. Now, in general, within the biotechnology industry, members tend to oppose this, as Robert Chess of Nectar Therapeutics stated during the hearings held on September 15th before the House IP Subcommittee testifying on behalf of Bio. For the biotechnology industry, injunctions work well. They see a narrowed injunction regime as akin in some ways to compulsory licensing. In other words, where an infringer can infringe when he knows that all he'll have to pay are reasonable royalties, which takes away an inventor's prerogative to pick and choose who you want to license your patent to. We've also heard some about the differences between different industries in terms of a so-called second window in post-grant opposition reform. In general, members of the biotechnology community support in varying degrees the creation of a properly drafted post-grant opposition system that would potentially serve as a tool to weed out some questionable patents. The computer and software industries support two post-grant windows in which a patent could be opposed, one immediately after issuance of the patent, and the second after the patent owner sends a notice of infringement. The second window, some of the justification, or one of the justifications that has been put forward is to allow companies to challenge a patent after it's asserted, even if a prior art search would not have revealed a threat from that patent, which certainly you would expect that to be more prevalent in the computer software industries where there are just so many patents involved and so many components. The biotechnology and pharmaceutical industries are against a second window on the basis that patent owners, essentially one of the arguments is patent owners should have a right to quiet title once the first opposition period is over. Without that, you have a cloud of uncertainty over issued patents, which can negatively impact the ability to attract investors, which is a big concern for biotechnology companies. A little afraid to put this slide up, but limitations on continuation applications. There was a provision in the original HR 2795 bill that would have authorized the PTO to promulgate rules to regulate filing of continuation applications. We've already heard some of the rationale behind this reform. My intent here is just to point out that, briefly, for biotechnology, yes, the industry is against significant reform of continuation practice. One of the things that wasn't mentioned in terms of one of the justifications or uses for continuation practice that biotech companies will commonly use is to obtain initial narrower patent claims that they can get to issue quickly, and then file continuations to seek broader patent coverage around their invention. And this provides some flexibility to obtain appropriate coverage for their inventions while at the same time allowing companies to use the narrower issued patent for generating investment capital. Venue reform. Here there's another divide between the pharmaceutical, biotech, and computer and software industries. Under the current law, a patent holder can bring suit anywhere that he or she can establish personal jurisdiction over the infringer, and this provides great flexibility to the patent holder in choosing the district for a lawsuit. Critics have complained that patent holders can bring suit for infringement in a district that has no connection, somewhat or little connection to the case. They argue that this has given rise to litigation abuses. Members of the biotechnology community are concerned about the various provisions that have been offered in different versions of the bill. They're concerned with what had been proposed with the substitute draft is that resource-limited biotechnology companies would be required to file lawsuits that are far outside of their normal jurisdiction. With respect to the coalition draft, They feel that it's also problematic because the transfer provisions could delay patent infringement actions to the detriment of small biotechnology companies. You'll see a theme here, and that is that with biotechnology companies, you have limited resources. Your focus is on trying to attract investment capital, and that's somewhat driving some of the views behind different reform measures. Now, so what's good? A couple of provisions here I just wanted to list out. We're getting short on time, so I'll just point out a couple. With respect to first-to-file, members of the biotechnology industry support efforts to harmonize U.S. patent law with other countries and simplify the patent process. From a practical standpoint, changes making it easier for an assignee with rights to an invention to file for a patent application are particularly desirable within the biotechnology community. In biotech and pharmaceutical industries, and in those areas where inventors frequently move between institutions, companies, and where rights are frequently assigned, the proposed changes would make it easier for a company to file an application without as much inventor assistance. The proposal would allow an assignee or a person owed an obligation to assign to apply for a patent after showing that the action is appropriate. This can reduce time spent chasing down signatures from inventors. The ugly, let me just mention real quickly, apportionment of damages was an area of particular interest for Chairman Smith, Chairman Lamar Smith, Chairman of the House IP Subcommittee, during the hearing September 15th. The damages provision prompted by, in part the nature of the products for computer software industries, attempts to control damages by focusing in on specific components of a product. HR 2795 directed the court to consider relevant factors, including the portion of the realizable profit credited to the inventive contribution distinguished from other features of the product, essentially codifying one of the Georgia-Pacific factors in determining royalties. Some members of the biotechnology community opposed the codification and potential overemphasis of one of these factors to the exclusion of the others, but again, there's some disagreement. Some feel that does no more than codify an aspect of existing law. We have just one more minute here, so I wanted to also just bring up a couple of other patent reform issues that have been near and dear to the biotechnology industry's heart, but that aren't present in any of the versions of the bill. Restriction practice reform. Quickly, it's not uncommon for biotechnology patent applications to receive dozens of restrictions for a single invention, which forces them to pick and choose which they want to prosecute and can potentially leave holes in their portfolio based on, it's a cost decision. What resources do we have? What can we pursue? And that can potentially impact the ability to attract investment capital. There have been efforts on the part of the biotechnology industry to implement or try to get the implementation of legislative action in this area. It's met with limited progress, but recently the Patent Office has initiated a study into restriction practice. They published a green paper proposing 4 different options for reform of restriction practice, put the green paper out, requested comments which were due last August. Word is that Chairman Smith isn't going to touch this issue again until after the PTO is finished with its study. And one last thing, fee diversion, something that has been bandied about for years. The practice of taking some of the income generated from PTO fees and diverting it to the Treasury's General Fund. This is not a part of the current bill, but there is a pending bill, HR 2791, that was introduced on the same day as the patent reform, that would establish a fee refund program. It would also make permanent the fee increases, the PTO fee bill from last year. This was approved by the full committee November 9th and reported out of committee and recommended for passage without amendment February 8th. And word is from the press secretary from the House Judiciary Committee that there's strong support for this bill in Congress. Thank you.
Thank you, Ed. I'm sure we'll have more discussion of the good, bad, and the ugly during our moderated discussion. Last on our panel, and but certainly not least, is Wendy Verlander, a partner at WilmerHale, the Wilmer Cutler Pickering Hale and Dorr, now called WilmerHale. She is, I think, going to be a very interesting speaker to have at the end because she has extensive experience in all aspects of IP litigation and across a variety of different sectors, including electronics, semiconductor manufacturing, mechanical devices, medical devices, and the life sciences, so perhaps she can provide us a little bit of cross-sector perspective. She has a very impressive background. She received her law degree from Columbia University Law School, where she was a 3-year Harlan Fiske Stone Scholar, and she received a bachelor's degree and a master's of science degree in mechanical engineering from MIT, where she was president of the MIT chapter of the American Society of Mechanical Engineers. She's been involved in a number of very prominent cases. For example, she successfully defended ASML Holding against Nikon in a patent infringement suit and achieved favorable results for a number of other clients in a number of different lawsuits before both the ITC and the Court of Appeals for the Federal Circuit. So, welcome.
Thanks, Arti. I was going to talk today about the role of certainty in patent reform and in patent laws in general. Thinking about the role of certainty, the proposed patent reform purports to increase certainty in the application of the patent laws, and I guess we should step back and consider what that means and how that impacts the goals of the patent system. And to do that, I stepped all the way back to the Constitution, which said that the patent laws are designed to promote the progress of science and useful arts by securing for limited times to inventors the exclusive right to their discoveries. And so the goal of the patent system right out of the Constitution was to promote the progress of science and useful arts. And the way I see it, promoting the progress of science and useful arts requires at least 3 things. First, inventors must achieve exclusivity to practice their inventions as a reward for all the work that they did, all the sweat equity, all the money that they've invested, all the time that they've invested. Second, inventors must disclose their inventions to the public so that future inventors can build off of that and continue to promote the progress of science and the useful arts. And third, the inventors have to have a firm idea where the boundaries are of these patented inventions so they can innovate without stepping on the other patents. Now, these concerns are not necessarily, don't necessarily work together. In fact, I see them as somewhat competing concerns. So how do we balance that? Well, the way I see it, you have to balance it by providing strong patent protection to inventors in exchange for full disclosure and providing proper notice to the public about the scope of these inventions. The proposed patent reform is very concerned about increasing certainty in the patent laws, which I think is an honorable goal and something that's useful, but when you push up against what the goals of the patent system are, I think the goals of the patent system should win out. And in certain instances, it seems that the proposed patent reform favors certainty over rewarding inventors, favors certainty over full disclosures, and in many instances isn't necessarily any more certain than the old patent system. So I decided I would look at a bunch of different provisions that are proposed in the patent reform bill, and the patent reform bill I'm looking at is the coalition red line that occurred in August and was discussed in September in the House. Just a little bit of background on that. Apparently the Senate has decided possibly to redo the whole debate. They are looking at it, and none of these provisions may ever come to see the light of day. The Senate decided that there were too many interest groups involved, as we can might be able to see from our panel, and that the potential reforms were geared too much toward the interest groups and maybe not enough toward promoting the progress of the science and useful arts. So the Senate may ditch the whole thing and do it again. The first provision I've looked at is the first inventor to file provision. Today, of course, I'm sure everybody knows, the first person to invent a certain subject matter is the person that retains the patent to that subject matter. And what the proposed reform would like to do is change it to a first inventor to file system where the first inventor to file is entitled to the patent regardless of who invented first. And this is intended to eliminate the uncertainty of, inventorship rights. Who invented it? There's always that concern, and costly inventorship fights. And I have to say, I was just involved in a big litigation in the Northern District of California this past December concerning inventorship. And inventorship is one of the messiest areas of patent law. There's no way around it. There's all sorts of subjective concerns that you have to figure out who invented what, when, what did they know, what did they think. Very difficult to litigate these issues. So there's no doubt that moving to a first inventor to file system would increase certainty, but at what cost? We should think about whether or not this actually fosters real innovation. I mean, what do we get by motivating people to run to the patent office and file as quickly as possible? Wouldn't we get premature disclosures, inventors that haven't had the opportunity to flesh out their inventions, to conduct the appropriate experiments, to come up with all of the embodiments that we'd like to see in order to give them this limited monopoly? Wouldn't this make it difficult for individual inventors and small companies who don't have the infrastructure in place necessarily to grind out all these patent applications the way that larger companies would? Query whether this will foster full disclosure. I mean, it seems that just the opposite. It will foster faster disclosure, but faster disclosure is not full disclosure. And again, in exchange for this limited monopoly, it would be nice to see inventors flesh out these inventions and actually tell the public what they did, rather than, rush to the patent office with any little bit of innovation and hope that that will carry the day. And the truth of the matter is, excuse me, a very small percentage of these cases actually end up in inventorship fights. The last statistic that I saw was that less than 5% of cases have inventorship concerns. In over 95% of the cases, the first person to invent is the first person to file the application. So having such a dramatic change to the patent laws, it seems, for such a small benefit, may be something that we'd like to think about. The second provision of the proposed patent reform that I was looking at is disclosure of the best mode. Today, inventors have a requirement to disclose the best mode that they knew of practicing the invention at the time they filed the patent application. The proposed patent reform wants to eliminate the disclosure of the best mode. And you can see why they want to do this. It's very difficult. Again, a lot of subjective inquiries in a determination of the best mode. You have to figure out what the inventor thought was best when. And in litigation, it's a very difficult thing to do. Again, I had one of the few cases that actually invalidated some claims of a patent based on a best mode inquiry, but typically it's really uncommon to be able to do this because you just can't get these subjective inquiries. There aren't documents to support it, et cetera. In my case, it was highly unusual. The patentee, happily for us, decided to publish a chapter in a book saying, our invention didn't work until we made this embodiment, and then it worked. And so we knew exactly what he thought was best and when he thought it, but that's an unusual situation. So truly, eliminating disclosure of the best mode would be an improvement with respect to certainty, but again, at what cost? should we really be trading an almost 20-year monopoly with an inventor and asking him to disclose inferior embodiments? And shouldn't it be a requirement of the Patent Office and requirement of the patent laws for the inventor to tell us what they thought was best? I mean, otherwise it'll be a game of hide the ball. I mean, as a practitioner, I can't imagine advising a client to disclose the best mode in the patent if there's no requirement to do so. And this way, the inventors will be able to have their cake and eat it too. They can keep as a trade secret what they thought was best, and they can get a 20-year monopoly to prevent you from doing anything that you think is best in that space. I don't think that would promote the progress of science and the useful arts. Certainly, you know, issues of full disclosure, as I've been talking about, will be compromised. Will it foster innovation? Well, it would be better if we knew what the inventor thought was best when we build upon it in the next invention. So I don't think it promotes the progress of science and the useful arts. The truth be told, very few patents are invalidated based on this best mode, as I said, though. It is a difficult to prove issue, and so there's a question of whether or not we should lean toward eliminating the subjectivity in the patent laws, or we should move toward, you know, some of the goals of the patent law, which is providing this full disclosure. The next provision that I looked at is a provision on invalidity and basically what constitutes prior art. And the proposed patent reform purports to change what is considered prior art to say that if a patent is invalid if the claimed invention was either patented, described in a printed publication, or otherwise, quote unquote, publicly known. Now, this is a big change from all sorts of on-sale bars, et cetera, that had existed in the patent laws as they are today. And query, what does publicly known mean? Well, the proposed statute gives some guidance. It says the invention is publicly known when it is reasonably and effectively accessible through use, sale, or disclosure. Well, that made me scratch my head a little bit. So in the quest for certainty, what does that mean? The statute gives some guidance on it, though. It says the invention is reasonably accessible if persons of ordinary skill in the art are able to gain access without undue efforts. And it's effectively accessible if persons of ordinary skill in the art are able to comprehend the content of the subject matter, again, without undue efforts. Well, that made me scratch my head yet again. And what does it mean to do all this without undue efforts? Unfortunately, the statute is silent on that. And so there is no guidance as to what the meaning of undue efforts is. And it makes you think, you know, what is reasonably accessible to one skilled in the art? Would sales in foreign countries be reasonably accessible? Well, it depends, right? Depends on the art that you're talking about. If you're talking about the pharmaceutical arts, well, I would bet that every competitor in there knows what's being sold in a foreign country. If you're talking about computer science, some of the electronic arts, or, you know, some very small arts like the sale of pens, my guess is you won't have any idea what's being sold in foreign countries. Same thing for presentations at foreign conferences, devices operating in foreign countries, et cetera. And what's reasonably understandable? Well, are internal processes used in products reasonably understandable? Would it take undue effort for someone of skill in the art to reverse engineer a product and figure out how it worked? We don't know the answer to that. What about presentations in foreign languages? Would it take undue effort for someone of skill in the art to get it translated? We don't know. These are all open questions, and so in the quest for certainty, I would say these are highly uncertain provisions. Another provision that I looked at is the duty of candor, and this is a codification of Rule 56 from the regulations, and so it's not a completely new provision. It is certainly new to show up in the statute, but it added a few things that I thought were interesting in the quest for certainty that the patent reform wants to have. What the duty of candor is proposed to say is that a patent can be rendered unenforceable if the patentee violated his duty of candor by knowingly failing to disclose or misrepresenting information to the Patent Office known by him to be material, with an intent to deceive or mislead, and the Patent Office relied upon the patentee's misconduct to issue at least one claim which the court finds invalid because a competent patent examiner either would not have issued it in the absence of the misconduct or issued it based in whole upon the misconduct as evidenced by the prosecution history as a whole. Now, I don't know about you, but there's an awful lot of subjectivity involved in that inquiry. And I think the purpose of putting it there was that they just wanted to take all the subjectivity out of all of the other provisions and dump it into this duty of candor provision. And Arti is laughing, but I was reading, the white paper on this, and basically that's what they said they were doing, which I found very odd because litigating it under this provision is just as difficult as litigating it under any other provision. So, as you probably have figured out, this duty of candor statute would require a subjective finding of what the patentee knew, what the patentee intended, and if the patent office actually relied upon it, all things that are really hard to litigate. The next provision of the proposed patent reform that I looked at is actually my favorite. It's the post-grant opposition provision, and I actually think this is a terrific idea. As a litigator, you see, a lot of defendants dragged into court, dragged through all sorts of procedures without any opportunity to try and do something, any effective opportunity to try and invalidate the patent ahead of time. I mean, the way our reexamination procedure these days is set up is rather ineffectual. So the post-grant opposition procedure would allow you within 9 months after the grant of the patent to oppose on the basis of invalidity. Unlike what Ed said, I think the second window is a terrific idea. Again, as a litigator, you have to think, you may not be able to know what patents have issued in the first 9 months after grant, but you certainly know what patents have issued after someone threatens to sue you. And so that was the second window, is someone threatens a lawsuit, you can institute a post-grant opposition proceeding within 6 months. Which I think is a terrific idea, but we can talk about that later. In any case, it comes with its own warts. It comes with an estoppel provision, and anyone who knows anything about the inter partes reexamination procedure today knows that the reason why nobody uses it is because it has really harsh estoppels. You're basically, if you use it, you're stopped from making these arguments in a future court litigation, and so people just don't take advantage of it. And what this provision says is, if a decision has been rendered in an opposition on a question of patentability raised by an opposer, that opposer is barred from asserting in any subsequent proceeding, that's any PTO proceeding or any court proceeding, that any claim of the patent already addressed in the opposition is invalid if the invalidity was based on an issue of fact or law that was decided in the opposition, and that issue of fact or law was necessary to the determination of patentability. And there's an exception to what seems to be an awfully broad estoppel. The estoppel applies except when an opposer demonstrates in a subsequent proceeding that there's additional factual evidence material to an issue of fact where that fact was actually decided and necessary to the final determination of the opposition, and the additional evidence could not reasonably have been discovered by the opposer. And then you can raise that issue of fact in any related issue of law that relies upon that fact. Well, what are the issues here? Who knows what was necessary to the determination of patentability? I mean, it's a very ambiguous thing to figure out. It's hard to litigate. Also unclear, what factual evidence could not be reasonably discovered by the opposer? There's very limited discovery in these proposed opposition proceedings. There's just depositions, no document discovery, so I suppose that there's that argument. But, who knows where this is going to come out? And the ambiguity is a bad one because people may not take advantage of these post-grant opposition proceedings just for fear that they're going to be stopped from using it in some future contentious proceeding, or possibly, they won't know if they can engage in a subsequent proceeding because of these estoppels. So it's an area of uncertainty that actually may undercut that proceeding the way the estoppel provision has undercut the reexamination proceeding. So the last, and it's certainly not the last provision that I thought was uncertain, but it was the last one I was going to talk about due to limited time, is the reasonable royalty provision. And what that says is, in determining a reasonable royalty for a combination, the court shall consider the portion of realizable value that should be credited to the inventive contribution. again, I was scratching my head. How do you do that? You know, how do you figure out the realizable value that can be credited to the inventive contribution? I mean, typically, you know, your invention is in something much bigger. So if you're talking about the fuel injection system in a car, what's the realizable value of that fuel injection system? It's hard to say. And another question is, why did Congress choose this factor? There are 15 factors spelled out in the Georgia Pacific case talking about what's pertinent to reasonable royalty. They're only suggestions, actually. They're not really requirements. But this is one out of the 15 that Congress decided to codify, and in a quest for increased certainty, really have to wonder why choose this one. So, in sum, I think that two major problems exist in the proposed patent reform's quest for certainty. The first is, does the request for certainty butt up against the goals of the patent system, which is to promote the progress of science and the useful arts? And second, do these proposals make the system any more certain than the system is today? And I guess on that note, we should think about whether or not it's possible to really make a system where we feel that it's certain, and if that's a goal that really should be at the forefront of patent reform, or should we just be back at what the goals of the patent system are supposed to encourage? Thanks. And I was asked... I was asked to tell you that we now have a 15-minute break before the panel discussion.
Yeah, actually, we're running a little bit behind, so how about make it about 10 minutes? And then just a couple real quick announcements. The bathrooms are right to the left of the reception area, and also there are a couple computer terminals outside. Feel free to use it if you need to check emails or anything. So thank you.